Welcome to the Appellate Division First Department. We have almost 5 hours of argument time requested today. Therefore, only ask for the time that you need. We're familiar with the briefs, we're familiar with the records. If we have more questions, we will keep asking them. People versus Davis. Appellate?
Appellant, 6 minutes and 2 for rebuttal.
Respondent, request 6 minutes, Your Honor.
I'll give you 5, 1, and 5. Elizabeth versus Wilfredo. Is anybody here on that? Submitted. 5 Star versus AJ Pegno. Appellant?
Thank you, Your Honor. Matthew Higgins for appellant here to introduce Jess Ellsworth, who the court has submitted pro hoc PJ to deliver argument.
Okay. And how much time are you requesting?
Request 8 minutes for opening and 2 minutes for rebuttal.
Respondent?
8 minutes for.
I'll give you 7, 1, and 7. Barisha versus 4042 East Tremont. Appellant? Respondent? I'll give you 7, 1, and 5. People versus Randolph. Appellant? Respondent? 4, 1, and 4. Pinpoint Builders versus Golden Insurance Co. Appellant?
Respondent requests 5, Your Honor.
4, 4, and 5. People versus Martin. Appellant? Looks like there's no respondent. Do you wish to submit? Okay, it's submitted. La Patner Project versus 320 West 115. Appellant? Respondent?
5 minutes, Your Honor.
7, 1, and 5. Sardo National versus Lobe. Appellant? Respondent?
10, Your Honor.
I'm going to give you 6, 1, and 6. Dowey versus 730 Fifth Upper. Appellant? Respondent?
Respondent, 5th Gen, request 5. Respondent, CBLA, request 3.
6, 2, 5, and 3. Pietro Forte versus Bell Harbor.
Respondent, appellant, request 3 minutes, Your Honor.
Okay, and you know that the appellant's not here, the main appellant. What?
I'll submit.
Okay, and is anybody else here on that case?
I wasn't sure if the other respondents were appearing. That's fine.
Okay, so do you want to just submit?
Yes, Your Honor, thank you.
Okay. Mamatuclo versus CUNY. Appellant? What? Are you the appellant? Are you the person bringing the appeal? Yes. And how much time are you requesting? You know what, I'm just going to give you 5 minutes, and I'll give you 5 minutes, okay? And that case is going to be called first, because we have someone vouching in, and Justice Bahati Pitt will be recusing on that. Watts versus American BD is submitted, and Gleitman versus Kushner is submitted. So the first case will be Maculo versus CUNY. Okay, you're going to have 5 minutes to present your argument, and you'll stand up here and tell us what you wish about your appeal.
Good afternoon. I want to thank you for having me here today. I formally request a reinstatement at Hunter College, as I believe that the circumstances that led to my expulsion were a result of my undiagnosed medical condition and lack of awareness of them. I was raised in a low-income family, and due to financial constraints, my parents were unable to provide me with regular medical care during my formative years. Consequently, my bipolar disorder and autism went unnoticed for significant parts of my life. It was only after my expulsion from Hunter College that I was admitted to psychiatric hospital, where I received a proper diagnosis and learned about my disability. Since then, I have been under the care of dedicated psychiatrists and therapists who have been providing me with necessary treatment and support, including medication management. This intervention has been important in helping me understand and manage my conditions effectively. I would like to express my sincere remorse for any disruption or inconvenience my actions may have caused during my time at Hunter College. Please understand that everything I did during my enrollment was in good faith, and I had no knowledge about my medical condition at the time. With the guidance and support of my medical professionals, I'm now better equipped to manage my health and well-being. I'm eager to return to Hunter College and resume my education and work toward achieving my academic goals. I kindly request the opportunity to discuss my reinstatement in further detail with you or relevant committee. I'm committed to taking necessary steps to ensure my success as a student in Hunter College, including working closely with appropriate support services to accommodate my specific needs. I appreciate your consideration of my request for reinstatement and the chance to continue my education at Hunter College. Thank you for your time and understanding.
Thank you.
Good afternoon. May it please this court, Anthony Radawatso on behalf of CUNY. This court should confirm CUNY's determination to expel petitioner after he was found guilty of cheating on multiple exams, fabricating a positive COVID-19 test result, failing to follow a mandatory quarantine order during the height of the pandemic, and sending hundreds of harassing emails to a college professor when he was repeatedly instructed to stop. At the outset, all of petitioner's claims are time-barred here. But even if this court decides to reach the merits, CUNY's findings were supported by substantial evidence, including petitioner's own admissions of guilt on the cheating and plagiarism charges here. And despite petitioner's unpreserved claims of procedural error, he was afforded all the process that he was due, and he was twice given the chance to administratively appeal the college's determinations. Finally, the penalty of...
Counsel, are any of the medical issues that he just raised in argument in the record?
Yes, Your Honor. He was registered with the Office of Accessibility as having bipolar disorder and ADD. This was not new. The school accommodated these diagnoses, including by giving him extra time on exams. Finally, I'll just note the penalty of expulsion here does not shock the conscience given the serious nature of petitioner's offenses, his history of similar misconduct, and his continued attempts to evade responsibility. I'll note at the outset again, this action is time-barred. CUNY's final determination on his expulsion was November 17th, 2021. He had 4 months to initiate this action. He did not do so. He waited until May 2022, so that itself warrants dismissal here. But even on the merits, substantial evidence supported the college's determinations. For example, on the plagiarism and cheating charges, again, he admitted to copying verbatim exam answers from a previous student's exams from a previous semester, on at least 2 occasions. But Professor Frida Kleinman also testified that when she investigated this, she found evidence of systematic cheating here. And the petitioner himself attached several text messages to his own Article 78 petition that showed him cheating going back to October 2020 before he even enrolled in Professor Kleinman's class. CUNY's additional determination that petitioner violated the Henderson rules, which require students to comply with lawful directives of college administrators, was also supported by witness testimony, including Professor Kleinman, who testified that he sent 160 separate emails to her after he was repeatedly instructed not to have any contact with her. These included emails where he threatened to throw himself under a train if she did not drop the disciplinary charges against him, falsely asserted that his hand had been amputated in a suicide attempt that he blamed on Professor Kleinman, and falsely asserted that his mother had perished from COVID and that his father was gravely ill in an attempt to gain sympathy. He also threatened to confront Professor Kleinman at her office if she did not agree to talk to him about the disciplinary charges against him, and he did in fact show up to her office. In addition, the college introduced testimony about a separate incident in April 16, 2021, where petitioner arrived on campus after he was instructed to quarantine following his claim that he was infected with COVID-19. Despite repeatedly being told that he was not allowed on campus, he refused to leave until he was physically escorted off premises. I will address Your Honors the due process claims. I'll note here that he had multiple opportunities to administratively appeal, as I mentioned, and briefly on the expulsion issue. Given his conduct here, the systematic cheating, the others, his harassing conduct, and complete disregard for the college's directives, the serious nature of his offenses and his previous history of misconduct, this is not the first time he has violated the Henderson rules in this way. All of this shows that a lesser penalty here would not effectively have deterred future conduct from him. I ask this court affirm. Thank you.
Thank you both very much. The next case is 5 Star versus A.J. Pegno Construction.
Your Honor, Davis case?
I'm sorry, what?
I thought James Davis, we were going back to James Davis.
Oh, I'm sorry. Somehow I read it as submitted, which was a mistake. My apologies. People versus Davis.
All right, I'm 1 for 1 so far.
I would never want to deprive you of your argument time, sir.
Good afternoon, Your Honors. David Crow, Legal Aid Society, representing Mr. Davis. This is an appeal from a denial of resentencing under the Drug Law Reform Act of 2009. In all likelihood, it's the last DLRA case that this court will see. The DLRA dates from 2009 and was considered very successful, resulted in shorter sentences for hundreds of defendants throughout New York State, reduced the prison population, especially when we're talking about the low-level street sale, the $10 sale, which was Mr. Davis's original offense.
What about, why don't we get to the merits, which is why substantial justice would be served in this case by resentencing?
Yes, Your Honor.
Or would not be served by resentencing.
Exactly.
I mean, we
First,
raised that.
first, we should note the presumption in favor of resentencing and start with.
Weren't there an extreme amount of reasons here why resentencing was not appropriate, including that he had escaped from prison, which is part of why this is one of the last cases, because of the delay, because of his large period of escape, and also all his serious infractions while he was in prison and his murder conviction.
Yes, Your Honor. So those were all
There's a
events
lot of
that.
factors that militate against a resentencing.
Those were all factors that the lower court cited. They all date from 20 or 25 years ago. And the error in the lower court's decision, which is contrary to the statute, which directs the court to look at the overall institutional record since the time of the original sentencing, is to look at the whole person and the passage of time. So here, Mr. Davis was amply punished in Connecticut for those other offenses. I think what's unusual about this case is that his evidence of rehabilitation was submitted in Connecticut and was the subject of a very careful reexamination by the Connecticut courts and 2 district attorneys in that state, and they all agreed that there was significant evidence of rehabilitation. Mr. Davis had gone to college,
also,
served
though,
as a
get a
mentor,
much-
and they reduced his sentence.
Didn't he get a much lower period of time than he otherwise would have in this case because the people were not ready to challenge his first-time felony offender status due to the circumstances where it's pretty clear he was a second-time felony offender?
Well, he was adjudicated and sentenced as a first felony offender. I
Thereby
acknowledge-
already giving a much more reduced sentence than he otherwise would have gotten if that had been adjudicated.
Yes, and that was cited by the lower court in denying resentencing. The issue of predicate status, at this point, I think it's the only complicated part about the
Counsel,
case.
if we remand it for a hearing or sorry, determination or resentencing, would that be something that could be litigated, the issue of his predicate status?
Our position is no, and we addressed that in the brief, that the people at that time had a full and fair opportunity to litigate, and it resulted in a first felony offender, and we believe that is essentially law of the case. And we talk about the Caval case and some of the other cases from this court.
Doesn't that really support the whole idea that substantial justice wouldn't be furthered by resentencing here because already got a reduced sentence under the circumstances?
I mean, it's hard to say, Your Honor. He was adjudicated a first. He received a 12-year sentence at that time, which even for a first felony offender was quite long. And I think today,
You don't mean
30
12,
years
you
have
mean
passed.
4 to 12. You mean 4 to 12.
4 to 12, yes.
Wasn't a 12-year sentence. Was he approved for early parole?
Yes, he was. Yes, he was. After the decision in this case, docs looked at his overall record and granted him release at the earliest possible date, the so-called supplemental merit release date. And so, Your Honor may be asking, what's his interest in continuing the resentencing process since he was released on parole. Obviously, he's on parole now, still serving the sentence. We would like to pursue resentencing unless and until parole actually discharges him, which might happen next year by discretion, might happen at some point in the future. But for now, he's still on parole. It's still limiting his freedom. And so we would very much like to pursue resentencing on his behalf. But yes, every court and docs which has looked at his case has said that by the passage of time, he has earned some degree of leniency, and we certainly think under the DLRA, the original circumstances of the offense, as well as his rehabilitation, show that there's a case for some degree of leniency here as well.
Thank you.
Thank you.
May it please the court, Amanda Regan on behalf of the people. The court below correctly found that substantial justice dictated the denial of defendants' request for resentencing under the Drug Law Reform Act. As the lower court correctly recognized, the defendant here is readily distinguishable from a low-level drug offender that the DLRA was designed to benefit because of his violent criminal.
So notwithstanding that defendant has committed some very serious crimes, including murder, he has received considerable leniencies to this point, has he not?
Yes, he has, and defendant is essentially asking this court to excuse his behavior in the instant crime, the drug sale crime, by granting him further leniency, and to do so would just be inappropriate and would grant him a benefit to which he's not entitled. As this court has already recognized, the reason for the delay in sentencing, in the resentencing, was because he had brazenly escaped from prison after committing and pleading guilty to murder in Connecticut, and then being picked up in New York on this drug sale case.
When he was, turn on my mic, and when he was picked up on that drug sale, he gave an alias and a false date of birth, right?
Yes, he did, and he refused to admit that he was the individual named in the predicate felony statement, which was the reason that the people were unable to litigate that issue. Even assuming arguendo that this court sends this back for resentencing, we should be permitted to relitigate, or I'm sorry, not even relitigate, litigate the predicate felon question, because it was never litigated before.
But that was because the people weren't prepared to litigate it. It was no action on his part. It's that the people couldn't get their stuff together.
No, not entirely, Your Honor. It was because the judge had a scheduling conflict for the date that the people had arranged for their witnesses to come from Connecticut. And when the judge rescheduled it, those witnesses were unable to come, and the judge would not allow us to adjourn it once more to get those witnesses in. So it wasn't that the people refused to or did not want to litigate the question. It was a question of scheduling and unavailability of witnesses. And the defendant now has substantially changed his position. He's freely admitted that he committed that murder in Connecticut, and even went so far as to submit a letter of apology to the victim, in that case's family, as part of his case for why he should be granted leniency by this court.
23 infractions while incarcerated, is that something in the distant past, or were they more recent?
The most recent one was in 2009. The rest of them were in the more distant past, but they're still part of the totality of what the court was able to consider at the time. And I'd just like to remind the court that resentencing is not automatic, it's not mandatory, it's a question of discretion. And here, every indication is that Justice Merchan exercised his discretion correctly in denying the motion for resentencing because substantial justice just did not dictate that that was the right outcome in this case. And unless your honors have any other questions, we ask you to affirm.
Thank you very much.
I would just like to, I think, address the procedural issue that we identified in our brief as well. In addition to the merits, the substantial justice issue, there was the fact that the court reached the merits without affording either myself or my client a chance to appear, which was clearly erroneous under the Court of Appeals precedent in the Golo case. Obviously, we've got a lot of things going at the same time here. So we've talked most of our time about the substantial justice issue. At a minimum, under the case law, we are entitled to a full and fair determination of the substantial justice issue where my client is present and has a chance to address the court. So we think that's the minimum.
Below, did defense counsel even request a hearing below?
That was myself. I was below. So no, we were never given a date to appear. We were exchanging papers, and I was waiting for the case to be put on for a date so that we could talk to the judge. But we got an order indicating no more papers to be submitted. And then the next thing we got was the court's decision in the mail. So my adversary argued that I waived my client's right to be present. Nothing could be further from the truth there. We never had a chance to appear.
Just one quick follow-up. So when that happened, when the people said you waived it, did you then object that that's not the case? I want to be heard. My client wants to be heard?
As I say, Your Honor, we were never on the calendar.
I see.
So I considered obviously doing a motion to re-argue, but at that point, the error had been committed, and I believe the case law makes clear, including Golo, my adversary looked into the question whether there was an exception or objection. Obviously, if I had been there, I would have objected and tried to avoid all of this, but under Golo, we were not required.
Thank you very much. 5 Star versus Pegno.
Good afternoon, and may it please the court. Jessica Ellsworth for the appellant Pegno Tully. Last year, this court vacated the judgment in this construction delay.
Let me ask a specific question, because your whole argument seems to be that the court did not apply a sole proximate cause standard as per the Second Department decision. But didn't we issue a decision where we were very clear about exactly what standard should be applied? And what I would like to know is how the court below deviated in any way from the standard that we articulated should be applied in this case.
Certainly, Your Honor. I think the trial court understood that this court's opinion directed it to apply the sole proximate cause standard. It cited—
Did you use the language sole proximate cause in our prior determination?
You didn't, but you talked about what damages the defendant alone had been responsible for.
Conceptually, why should there be a sole proximate cause standard? You're talking about a construction site. There's a lot of things going on at the same time. If you bear a lot of responsibility for delay, shouldn't you have to pay for the delay that you cause, even if there are other participants in causing the delay?
Your Honor, I think New York law is crystal clear that the financial responsibility for delay can only fall on a party if they are solely responsible for that.
What makes that crystal clear in New York? Is it the Plato decision?
So the Plato decision is one of the cases that makes it crystal clear. And in that case, the court actually set aside a damages award on the basis that there was extensive evidence about concurrent delay in the case.
Where has the First Department held explicitly that in a construction delay case, it's a sole proximate cause standard?
So in Plato, the court cited to this court's decision in Manshall, which addressed that same issue.
Doesn't Plato heavily rely on non-New York precedents?
No, Your Honor, I don't think that it does. And I'd also point out that New York precedent on this is consistent with the precedent everywhere else. The appellee here hasn't suggested that there is a different standard that applies, and the Supreme Court didn't think there was a different standard that applied. It's cited to Plato.
Counsel, if I may, and we're talking about Plato now, and I think you may be relying on this statement, under such circumstances, recovery of delayed damages is precluded since defendant is not the sole proximate cause of the delay. And so as my colleague asked you, Justice Friedman, the citations for that sentence is not to New York authority, but to state federal authority. Correct?
That is correct. That is among the cases that are being cited, but those cases are applying New York law. We also provided a number
Federal. I just read the sentence, and that's a citation to a state federal case.
That's correct, Your Honor. Again, I would note, though, that no one is disputing that this standard applies. The question is whether the evidence in this case meets that standard, and we provided 16 different examples in our brief.
Counsel, I mean, I feel like this issue was litigated, and when the court issued its decision, it was very clear and as to what we intended, because we did not, in fact, say the sole proximate clause. We said that the damages should be weighed after considering what the city might be attributed to, but we didn't muddle our words. So I'm just wondering where you're drawing your distinction. I understand you're relying heavily on that case, but as my colleagues pointed out, and as that case was argued before, when we decided the first issue, it wasn't something that we followed then. Why should we go back now and do that?
So, Your Honor, I don't think you have to change anything from what you said before. This court's decision said that the reassessment should weigh the damages caused by the defendants, and this is a quote, after considering the delays attributable to the city. Well, there are delays attributable to the city here that were not considered. Those are the delays, just to take an example of this unexpected oil plume that was found underneath the site.
But then, oh, I'm sorry, go ahead.
Go ahead.
Despite
when it was sent back, the judge then went down. He looked at the experts' affidavits and reports, and then he came to a conclusion, weighing those decisions, and that's where we are now.
So, Your Honor, I think the easiest way to know that that's not what happened is, there's actually two easy ways to know that's not what happened. The first is that he simply, the judge below simply repeated the 79% number from his earlier decision. That 79% number is not even what 5 Star's expert offered. He actually gave a 76% number. So he didn't even pick the right number out of the expert report. But he also didn't cite anything in stating that the expert had applied this standard, had applied consideration of delays attributable to the city. And we know the expert didn't.
What is the reason that the requirement should be that it be the sole proximate cause? You know, here they find, there's a finding that you're 79% responsible for the delay. Why shouldn't you be responsible for that, even if there's another entity which also causes delay?
So, Your Honor, the fact of the matter is that because this delay would have occurred no matter what Pegno Tully did, the delay from the unforeseen oil plume, from the tie-back anchor design, from the foundation design flaws, these would have caused delays no matter what my client did.
In effect, what you're saying is if you've got 3 entities that are responsible for the delay, one is responsible for 98% of the delay, and 2 other entities are each responsible for 1%. The one who's caused 98% of the delay doesn't pay anything for that.
Your Honor, in this case, I think it's particularly unfair because 5 Star stands in the shoes of the city. It is a third-party beneficiary of the city's contract with Pegno Tully, and so to the extent that 5 Star is able to recover damages from Pegno Tully when there were delays caused by the city, when 5 Star is really in the city's shoes, that injects an incredible amount of unfairness and uncertainty into what has always been established New York law. There is no case that the other side has cited that adopts a different standard, and the trial court in this case understood it to be the standard that applied. When there is an unforeseen oil plume, there are tie-back anchor design problems, there are foundation problems, those all impact the flow of this project at least as much as Pegno Tully's conduct. And so under this court's language, they can't be included in any financial award. Thank you.
May it please the court, Mark Canizio for the respondent, 5-Star Electric. Just addressing some of the points that you've hit upon, the standard is set forth in the Manchel case and cases in our brief cited at page 19 through 20. There are numerous cases apportioning the responsibility for delay damages in construction cases. Any number of those are cited there. Conduit Foundation Corp., Columbia Asphalt, Worcester Electric, a number of cases that all talk about an apportionment of responsibility. We're here, as the court may recall, we were here, I believe it was in 2021, when the judgment came up on appeal, and the problem at that time was that, at least I believe in the court's eyes, was that the trial court found the defendants 100% responsible for all delays on the project, notwithstanding the fact that our experts said.
You do want us to depart from Plato.
I don't believe I don't believe Plato is applicable or a departure is required. The standard is set forth in the First Department cases, in the Manchel case versus Dasney and others. Basically, it requires you to establish that the delays were caused by the other party and to eliminate overlapping delays if there are any. Those delays are always measured in construction cases by examining the critical path for the work. Was a delay on the critical path? Did it make the project take longer to complete? All of the arguments addressed with respect to specific change orders were vetted by the trial court. There was testimony from both sides. I mean, for example, the oil plume, this was the former site of the mobile oil tanks. It was expected that there would be contaminated soil. Part of the contract was to remove
What
that.
about this? Your adversary makes the point that we can infer that the judge really didn't change anything because he made the same error of if it's an error of 79% as opposed to what the expert said, 76%. Should we be looking at that?
So the expert said 79% through substantial completion, which is the date during which construction damages are measured. These were damages for extended general condition costs, and they ran through the date of substantial completion. The 76% referenced final completion, like completion of punch list work and things of that nature, and I don't think that was specifically part of the damages that were being alleged, which is the reason he picked that 79%. But he definitely, in response to the court saying, you can't hold them responsible for delays that are caused by the city, he went back, looked at the expert's report, and determined that the 79%, as stated by our expert, was credible. And he also made, in the prior decision, he made a specific finding that the expert of the defendants was not credible based on various things that occurred during the trial, and he rejected that testimony. If you look at counsel's brief, they only cite to two things. One is the rebuttal report of their expert, which was rejected by the court. And the second thing was these narrative update reports, which weren't even admitted into evidence during the trial. They were, and they say that based on an affidavit that was submitted on an in limine motion in which the witness said, yeah, the city has no objection to, not the city, 5-Star has no objection to the admission of these documents, but they were never offered or admitted at trial. Now, the appellate counsel is not the same counsel as was trial counsel in this case, and we've pointed that out in our brief, but to no avail. Exhibits in this case were either put in through witness affidavits or through cross-examination, but they have to be offered at some point in time, and none of these narrative updates were ever offered into evidence by the defendants. With regard to this belated argument that 5-Star Electric somehow or other stands in the shoes of the city, This court ruled on another appeal, perhaps 2 years prior to that, maybe it's in 2019 or 18, that that's not the case. And that was when we were asserting the claims that, it was alleged that we were asserting the claims as third-party beneficiaries of the city contract, which was not the case. The contract, as all city construction contracts do, contains a provision which says if you're damaged by another contractor, another prime contractor on the project, you have the right to go against that contractor for damages, which is what occurred, and they have the same provision in their contract. Pegno Tully could go against.
It wasn't based on the rights of the city, it was just based on a provision of the
Based on the provision of the
And
contract.
that's the same provision that was in your contract?
Yes,
In their contract?
that's correct, Your Honor. And again, so just with respect to particular problems like, found the change orders that were dealt with, the foundation changes, that was all dealt with by the court. The court concluded that the foundation changes were decided, revised drawings were submitted, all before the excavation work was finished. So they just don't have an impact on the critical path of the project. They just don't delay the project. There's another whole host of change orders at the end of the appellant's reply brief that there was not a word of testimony about at the trial. And this is on page, if I have it open, 31 of their brief. They refer to changes 55, 84, 86, a number of different changes. Not a word of testimony by their witnesses on direct or on cross-examination of our witnesses. The only reference to them was buried somewhere in their expert's rebuttal report, which, as I said, was rejected by the court as not being credible. And there was never any demonstration as to how these changes purportedly delayed the critical path of the project. In order to delay the critical, they have an example in their brief which explains it. If you have a 2-week delay in receiving windows that have been ordered for the project, but the foundation hasn't been erected, it's not a delay to the project. And that's the kind of thing we're dealing with here.
Thank you very much.
Thank you.
I'm going to speak quickly in my 1 minute of rebuttal. The first is to point out that the 76% number that Your Honor asked about is actually through the date of substantial completion. You can see that at RA 278. So my friend on the other side's statement to you was incorrect when he suggested that was not the case. Second, the 5 Stars brief on page 18 specifically states that in Manshall, this court held that construction delay damages require a showing that there were no other independent causes of those same critical delays. Independent cause of the excavation delay here is exactly what the change order from the oil plume, the tiebacks, the soil conditions, all of that is independent causes of those delay days that their expert assigned to Pegno Tully. And you can see this if you look at the appendix pages 238, page 566, and page 375. In every case, their expert testified over and over, yes, there was concurrent delay, but I ignored it because I used a concept of overriding delay or driving force delay. That concept has no basis in New York law. Thank you, Your Honors.
The next case is People versus Randolph.
What happened to Barisha?
Oh, I'm sorry, I'm messing up today. Barisha versus 4042 East Tremont. My apologies. I'm racing through the calendar.
Good afternoon, Your Honors. Bernard D'Orazio for the petitioner appellant, Frank Barisha. The lower court here erred in 2 fundamental ways. So this case had an extensive prior decision by Justice Howard Sherman on the original petition, 23-page detailed decision.
Counsel, I know you spent a lot of time in your brief talking about law of the case and how law of the case was applicable, but Justice Sherman's decision was reversed by this court on the law And this court never addressed the factual underpinnings of his decision. So even if we were bound by law of the case, which we are not because we're an appellate court, I'm not sure why you keep referring to Justice Sherman's findings. The law of the case, we reversed them. We didn't get to the factual findings.
Well, the court didn't reverse, it modified. And it modified in a very limited way. I mean, Your Honor sat on the panel. The modification was simply not finding that there was any real transfer of the business. The issue.
But we didn't, by reversing on that legal issue, we didn't adopt or reject or make any findings with respect to the validity of Justice Sherman's factual findings. So they are not law of the case then, because that decision was not upheld. It had to be re-litigated as to the transfers, and a new determination had to be made based on our decision. So there is no law of the case, as far as I can tell. I'm not sure why that's one of your primary focuses in your
It's not a
appeal.
primary focus. We have two, but
It's a major focus.
a major focus because this court otherwise affirmed. It does say that, otherwise affirmed.
But we did not make any commentary about the correctness of his factual findings, and there was no need to, based on, the merits of our decision.
That's correct. So now we go back down, and because of the COVID pandemic, Justice Sherman is in retirement. We come back before new.
We don't know why he retired, but
Well, okay,
we won't muse
not in the
on that.
record, but okay. In any event, he's not on the bench when this comes back to be reheard. We have a new judge. But Justice Sherman's findings can't be ignored by the new judge. They're of coordinate jurisdiction. How could we have
why
a
don't you
new
make
judge?
the argument on the merits now, based on what the judge did now, versus referring to Justice Sherman's findings?
Okay,
Because
so
obviously they differed.
okay, well, we don't really know that because Justice Cohen simply said in a one-sentence decision, issues of fact requiring a trial. He did not parse through any of the evidence. He did not consider Justice Sherman's findings. He did not find they're not supported by the record. He made no
I thought
comment.
he made reference to conflicting affidavits, which would lead us to believe it's a credibility issue, and that's why it warrants a trial.
He referred to one thing. He referred to a denial by Eddie Sujak that he forged his brother-in-law's name on the checks of supposedly his brother-in-law's company. Now, we have an affidavit from the controller that Sujak hired, admitted by Sujak, who was working in his office, admitted by Sujak.
Let's go to a much more fundamental issue that the affidavit addresses, which is the reason for the transfer. Because for the transfer to be fraudulent, it has to be done for a fraudulent reason. Why isn't it sufficient to raise an issue of fact based on the affidavit that the reason for these transfers were not fraudulent at all, but were due to family problems? Why aren't they entitled to have a court or a jury make a credibility determination one way or another whether or not that is true?
For a plethora of reasons, right? So among other things, the credibility of Eddie Sujak is nil, right? We have him lying.
You're saying we should decide as a matter of law to disregard his factual affidavits?
Well, it's incredible. I mean, Justice Sherman found that. And it's also incredible, and this court could find it. This is a guy.
That is an issue for the jury. That's what the trial is about. Who do we believe?
What we're looking for is real issues of fact, not feigned issues of fact.
Why isn't that a real issue of fact?
No, I would say no.
You're saying just don't believe him.
But
That's
there's
why you're
more to it.
arguing it's not a real issue.
Well, it's more than that, though. It's not just not believe him. Look at the totality of the evidence, which is uncontroverted. Right. First of all,
What does Eddie say why he got out of the business?
he said that he got out of the business in 2006 when he sold the business to his brother Amir because he was tired of running the business.
And he
That's what
wanted
he
to
said.
help his brother out, right?
That's his brother Amir, yes, 2006, right.
And then later on, he wants to help his brother-in-law out.
Well, he doesn't own the business anymore, supposedly. So now all of a sudden, he's facing trial in this injury case. He has no insurance. He states on the record, I don't want to pay my attorney anymore. He admits that he intentionally defaults in the case, both his brother's business and his business. He originally admitted...
Didn't he transfer the first business in the first place before this lawsuit even happened? He transferred the business out of his name? I mean, the business was transferred to Tosca Cole before this lawsuit even began.
That's correct. That's correct. And in
So was that fraudulent then? I mean, how could that be fraudulent as to?
When no one's claiming it's fraudulent. Right. What's fraudulent is, it starts with this way, is during the injury lawsuit, the wrong entity is sued, Eddie's entity. He admits ownership on the day of the incident, falsely. The case goes on for years suing the wrong company. When it's finally revealed that the right company is his brother Amir's business, and they make a motion to amend to add it, 2 weeks later, they form the new company. And they start filing for a liquor license. It's all documented in the record. So while this is pending, they start forming the new corporation. The new corporation takes over the business in February 2013 with a case on the trial calendar. Motion to withdraw by the defense counsel pending. Sujak puts in an affidavit saying, I don't want to pay anybody any money because the plaintiff has no case. That's what he says. They intentionally default in the case and allow judgment to be taken against both entities.
And Radanchik executes a $400,000 promissory note at that time, right?
He apparently does. And that's the only documentation that there is. There are no contracts of sale. There are no corporate resolutions. There are no shareholder minutes. There's nothing. All this goes on behind the
To prevail here,
scenes.
don't you need to doubly pierce corporate veils?
No. You know why? Because the record evidence here shows
Isn't that what
what's
we
known
held
as
in our last
equitable.
decision, adding on to his question?
Well, we're talking about the concept of equitable ownership. First of all, there's no proof that these parties have ever put in of who owned these corporations, right? There's no proof. We've challenged them on this. They put in nothing. So it's just the word of these people about Sujak owns these corporations. The concept of equitable ownership in piercing the corporate veil is a person who exercises considerable control over a corporation and uses it to commit a fraud can be held liable piercing the corporate veil, even if not a shareholder.
Okay, we're going to let you go on in your rebuttal.
Okay.
Thank you.
Good afternoon, may it please the court. Kenneth Gorman for the respondent. There are questions of fact. We're just dealing with the pleading at this stage. There's no evidence that corporate formalities were not followed after
These
the person.
promissory notes create issues of fact when there's no evidence that any payment was ever made on them.
I don't think Amir made any payments on the $400,000 promissory note that he entered into in 2006. They made payments on the
And
lease.
Radanchik never made any payments, did he?
Excuse me?
Radanchik never made any payments on the second $400,000 promissory note, did he?
But his testimony was that he didn't have to make any payments on the promissory note, just he had to pay the rent if the business was not profitable. And this business was not profitable. I mean, the testimony is that this business was making on average $73,000 a year. And the central issue in this case, one of the most central issues in this case, is Amir's reasons for abandoning the restaurant in 2013. When Justice Sherman made his decision in 2017, there were different facts. I mean, Eddie said that Amir's son had a drug problem. Now, Amir's son has unfortunately passed away from his drug affliction on August 10th, 2020. And it made sense for him to leave because Basir helped him run the restaurant with his other son. And if he didn't have Basir to help him run the restaurant, and Basir had a drug problem, it made perfect sense to attend to his son's drug problem. Unfortunately, he was unsuccessful. And the June 29th, 2017 decision is not the law of the case. The decision was reversed by this court, and it incorrectly found that the 2006 transaction was fraudulent, and the entire underpinning of that decision was that 2006 transaction. And Justice Sherman's findings that Amir Sujak's reasons for abandoning the cafe were incredible, but we have his son dying of a drug overdose, which corroborates his reasons. And his final reason for saying that Eddie Sujak was guilty of a fraudulent conveyance was that he hired Rasim in 2008. There's 7 pages of Rasim Sujak's testimony in the record. I would urge the court that if the court's going to make any credibility determinations, the entire transcript should be in the record. But
Is that all?
that's all.
Thank you.
I think it's important to point out what we have from Amir. Amir is the brother, right? On the first application in this case, Amir defaulted. His company, Tosca Coal, ignored the case. After this court ruled in 2019 and we filed the amended petition, all of a sudden, Tosca Coal and Amir appear in the case without ever vacating their default. We rejected their untimely late response, a notice of rejection filed. They never moved to vacate their default, and that's where they are today, right? So they really shouldn't even be heard on this. So where does
If they're not heard, didn't they all appear together in this appeal? What practical, even if we agreed with you, what practical effect does it have on how we decide this appeal?
It's a question really of whether there's any evidence of Amir's story about abandoning the business while the case is headed for trial because of his son's problems, right? This is a self-serving story that's told now in an affidavit by Amir. We've put in the record as well, however, a prior affidavit by Amir from 2013, where he made a motion to vacate the default judgment. And in that motion, he claimed that they didn't get notice of the case, that he did not intentionally default in the case, and that he says nothing about abandoning the business, nothing at all about that whatsoever.
Thank you.
It's a completely
Your
concocted story.
time's up. Thank you.
Thank you.
Now we're calling People versus Randolph.
Good afternoon, Your Honors. May it please the court. My name is Mark Zeno, and I represent appellant Elijah Randolph. Respondent now concedes that the court below abused its discretion when it forbid defense counsel from asking the lead detective whether he'd twice been found incredible by New York courts. So the question before this court is whether Mr. Randolph was harmed by those errors. Mr. Randolph was harmed because there's a reasonable possibility that had proper cross-examination been allowed, the result of this case would have been different.
Counsel, was there overwhelming evidence that would suggest the opposite? His statements, the photographs, things of that nature?
No, there was not overwhelming evidence. To begin, the complainant could not make an identification in this case. To fill that void, in summation, the prosecutor...
Surveillance video of the defendant robbing Victoria Lopez, isn't there?
There's surveillance video of someone robbing Ms. Lopez, yes.
And what ties the defendant to what's shown in the surveillance video is the next day when the defendant is arrested, the pictures reflect that he's in the same clothes as worn by the person who committed the robbery of Victoria Lopez.
He had, the person that robbed Ms. Lopez appeared to have a blue Nike hoodie, and when Mr. Randolph was arrested the next day, he had a blue Nike hoodie. Whether they're the same hoodie was a jury question. And on that, I will point to the fact that the jury twice asked to see the video, then asked to see the still photos to review on their own.
Well, weren't they seeing whether it was the same person? I mean, was it...
Exactly. They were seeing, that's exactly what they were saying.
After reviewing it, it was clear to them...
After reviewing it, but also after having heard the testimony of Officer Magliano...
What about the fact added into all those things already, the statements that were made by the defendant himself about his gold snatching?
And can I just add to that? Add to that, Justice Kern, that during this same interview with Detective Magliano, didn't the defendant himself identify himself in the photos from the surveillance footage?
He identified himself in photos. Detective Magliano never said those were photos taken from the stills. We know there were photos, but there were 3 statements. 2 of those were made to Magliano, and that really circles back to my point, is that if the jury knew that Magliano was the type of officer...
It was a videotaped interview, so we have a videotape of the interview, so we don't have to assess Magliano's credibility, do we, to
during the
determine whether those
interview,
statements were made?
I'm sorry. During the interview, he did not confess to the crime. He said, "You say you have a video of me."
But he confesses to a series of chain snatchings.
He did not confess to a series of chain snatchings.
Doesn't he say he's going to cop to some of the robberies?
That was a statement after the fact, made to Magliano and allegedly in Gonzalez's presence. That was not on the video. And again, that gets back to the question of, trials, as I think was mentioned earlier in an earlier case, are about who do you believe? And if the jurors had heard that this was an officer who was willing to fabricate in two criminal cases, they might well have determined he was fabricating in this case. So, and would have been willing to conclude that two of those three statements, which were made to Magliano, were not actually made, and that's the price of putting on an officer who has lied before, and the jury never got the tools to assess his credibility. Thank you.
May it please the court, my name is Sheila O'Shea, and I represent the respondent on this appeal. The people do concede that under Rouse, the defense should have been able to cross-examine Detective Magliano about the two prior adverse credibility determinations. However, that's really beside the point, because this case, I think, was not overwhelming. One might even describe it as crushing. There were 5 pieces of evidence that all put together strongly established defendant's identity as the robber. First, you have the surveillance footage clearly showing defendant following Lopez down the street, stopping her. It might not have clearly shown him ripping the chain from her neck, but her testimony certainly established that happened. Then you see him running down the street again. You also have a very clear photograph, I think it's People's Exhibit 5C, which clearly shows defendant's face dressed in the Nike hoodie, the blue Nike hoodie in the subway station. The jurors could clearly compare that photograph to the defendant sitting in person and determine that he was in fact the perpetrator of the robberies. Second, you have Detective Gonzalez identifying.
So are you saying that the surveillance video itself shows the defendant even without the close connection?
It shows him, I think, with Lopez's testimony on the surveillance video, I think, yes, it establishes his identity as the robber.
In other words, Victoria Lopez looks at the video and says, that's the defendant?
No, she doesn't, but her testimony establishes that the perpetrator ripped her chain from her neck. And the jury, I think, could have looked just at the surveillance video and established that the defendant sitting in court was the same person on the surveillance video.
That's what I'm asking you, is what you're saying that the surveillance video itself, without anything else, if you look at the surveillance video and you look at the defendant in court, you say that that's the perpetrator.
Mm-hmm.
Is that?
Well, I'm not relying solely, as I said, there are 5 pieces of evidence.
You're saying that the jury could make that determination?
Yes, absolutely.
Without any other evidence?
Yes, but also we had the testimony of Detective Gonzalez, who had spent time with the defendant the day after, clearly remembered his face, had spent 4 to 5 hours with him. He identified defendant on the surveillance video as the man he had met with on August 30th, the day after. We also have the photographs that Gonzalez took showing that the defendant was dressed in the exact same blue Nike sweatshirt.
Are those the photos where he had his hand behind his back?
That's right, Your Honor, but to the extent the jury could infer that he was in fact handcuffed, and yes, the prosecutor did suggest that was a reasonable inference, I think it was prejudicial, but not unduly prejudicial, because...
So now we have 2 things that are prejudicial to him, the not allowing the questioning of Rouse, and now this photo of him.
I'm sorry, I didn't hear the first thing. I heard the second thing.
Not allowing the questioning of of Magliano, which you concede is, error, and the fact that they're showing this photo of him with his hands cuffed, hands behind his back, which can be inferred to be handcuffed.
Well, again, I think what the judge had to do, balancing, and yes, is it prejudicial to show a defendant in handcuffs or a picture suggesting? Absolutely, it's prejudicial. The question is it unduly prejudicial? And the probative value of the photographs was so high that I think the judge properly determined that the probative value outweighed the prejudicial effect, even had the jury infer that he was in handcuffs. I might add, though, the photographs gave no indication that they were taken at a police precinct. The defendant was dressed in neatly attired, no prison garb. The judge remarked that even though the photos were taken in the district attorney's office, they looked more like they'd been taken at a doctor's office or in a hospital. So I do think the prejudice was minimal. But at any rate, not unduly prejudicial. Prejudicial, yes. Unduly prejudicial, no.
Counsel, if I may, I want to address the statement because I know there were two statements.
Yes.
And that first one, and I'm just paraphrasing, okay? This is about the chain snatching robberies. Now, that first statement was unprompted, correct?
When he says this is about the chain snatch, yes, correct.
And the second statement was?
Second statement, also he asked to see the detective, and the detective went to meet with him in the holding area, and he said, I'm going to cop to 3 of them. I'm going to cop to 3 chain snatches, but I'm not copping to the ones I didn't do. So our position is with all that evidence, the totality of that evidence really leaves no question but that defendant was in fact the person who committed the robbery. So again, thank you.
Those two statements that opposing counsel just talked about were made to Detective Magliano, if we believe Magliano. But again, defense counsel wasn't equipped to impeach him correctly due to an error that the people now concede.
But how do you overcome, in light of all of that, the surveillance video?
I'm glad you asked that. I urge you, if you haven't already, I know the court has the surveillance video, I know you'll look at it, but I'm willing to say that if you look at that surveillance video, you'll realize that you cannot make an identification from it. Is the resolution sufficient to say that's consistent with my client? I agree with that. But can you make a definitive identification from it? I encourage you to make your own decision on that, because this case rises or falls on that.
Thank you.
You know, I think you make an interesting point about that you can't come to a conclusion from looking at the surveillance video, but when you put the other evidence into the case, even some that you say shouldn't have been considered, then recognize the surveillance video as being the defendant, and then that becomes compelling evidence of committing the crime.
Right, and as you recognize, Your Honor, it's our position that those statements, to the extent that they were made to Magliano, essentially need to be not considered because there was, as the people concede, a violation of my client's right to cross-examine. Thank you.
Thank you. Pinpoint Builders versus Golden Insurance Co.
May it please the court, Timothy Delahunt for Appellant Pinpoint Builders. In our brief, we fully address the completed state of the building for the sake of completeness, but that's immaterial and irrelevant because the exclusion at issue here applies to injury arising out of exterior work on a building with its height higher than 3.
You represent Golden?
No, I represent Pinpoint Builders.
From what story did the underlying plaintiff fall?
The second story.
The second story.
That's correct. At the time of the accident.
But yet there's all this talk about the building being perhaps 4 stories.
In his initial verified.
You look at the pictures of the work site, and there's a point at which it's clearly just 2 stories. Right. And then when the job's going on, it reaches a point where it's clearly 3 stories, and maybe there's something which could be considered a 4th story. So at what point did the defendant fall from an upper floor to a lower floor, whether it's the 3rd to the 4th or the 3rd to the 2nd? When does that happen?
He testifies, and there's no dispute of this. In the photo, the most important photo is marked as Exhibit E from his deposition, and he circles where he fell.
A51 on the record.
Yes, I was looking for that, Your Honor. Thank you.
Looks like that's why, because it's not clear. I'm struggling with that photo because it's not clear whether it's 4 stories or not from that photo. I don't know how you can decide definitively one way or another whether it's 4 stories looking at that photo.
Well, there's no dispute regarding the scope of the project. It was an existing home, 2 existing homes, with a cellar And the first floor and
being
the second floor.
combined.
Correct. They were going to be combined, and then a third floor was going to be built. When the plaintiff fell, there's no dispute that that third floor, the new third floor, had not been built.
So when we look at 851 Exhibit E, is that a photo that was taken, do we know if that photo was taken after the accident, or how does that photo correlate to the accident? How do we know that, looking at the record? How can we definitively decide how that photo correlates to the timing of the accident?
Well, he in conjunction with this photo, he testified, and he made that circle in red ink, okay, that if you see the opening within the red ink, that's the opening he fell through. And how this court can determine that that's the elevation he was on at the time. And he also, as an aside, he testified.
Well, wait, is the issue the elevation he was on at the time, or the issue how many stories the building is?
I don't think it matters, Your Honor, because either way, the building at this point in time was not over 3 stories.
So you just said that to take you back. You said it's undisputed that when he fell, the building was only 2 stories. Isn't that what you just said a moment ago?
It's undisputed that this was the condition, the state of the building when he fell. No,
When he
Exhibit
fell,
E.
is there a dispute as to whether there were 2 stories to the building, putting aside this cellar, which is not counted? There's a first floor, second floor. Was at the day he fell, is there any view of this that there was a 3rd story?
no, Your Honor. And the
And when
reason
your
why is,
adversary gets up, is he going to agree to that?
I'm sorry?
When your adversary gets up, is he going to agree to that, that when he fell, there were only 2 stories?
Golden relies on his prior incorrect testimony that it was the 4th floor, a 4th floor that never existed. And so it's not a real discrepancy because he
How
corrected.
can one decide as a matter of law, looking at Exhibit E, that it is or is not 4 floors? Because I'm looking at it and I'm not sure that I can tell clearly that it is or is not 4 floors. So how can the court support a determination based on this picture that as a matter of law, it's less than 4 floors?
There's 2 answers, if I may. There's the factual answer, which is if you look at the photos,
Sorry,
the
there's a
third.
what?
There's two ways to answer that question. With respect to the photo itself, you can see that the 3rd floor, the future 3rd floor, 1, 2, 3, was still was not a floor
Right, but it
yet.
looks like a floor.
Right.
It looks like an open floor, but looks like a floor.
But Your Honor, here's the legal answer, okay? Even if the existing cellar is not a story, so there's the existing 1st floor and there's the existing 2nd floor. If the court were to look at this photo and determine, now I don't think this is correct, but if you were to count that 3rd floor under construction, the building is still not over 3 stories.
And what about the structure on top of it? I'm looking at the photo again. There's a 1st floor, there's a 2nd floor, there's a 3rd floor in the process of being built, and on top of that 3rd floor, when you look at the photo, there's some kind of structure on top of that 3rd floor.
That's the elevator structure that the underlying plaintiff testified to being under construction. And in our brief, we do point out that that's a rooftop structure under the code and does not count as a story. And there's been no argument to the contrary on the law, and the facts are undisputed.
Let's hear from
Just on November 4th, 2015, was that the way the building looked?
Yes, plaintiff testifies in conjunction with this photo that this was the condition of the building, and there's been no argument or evidence to the contrary. This was how it looked as of the time of the accident.
Thank you.
Thank you.
Good afternoon, Your Honors. Joel Simon from Smith Major for the respondent.
So let me ask you just a question before we go on, and I'm sure you're going to address the excess issue on your other 4 minutes, so you'll have to address both. But I'm looking at the picture, whether or not that's a 3rd floor being built. Do you concede that that structure above the 3rd floor in this picture is not a floor?
Your Honor, I don't know what it is, and that's part of the problem.
Well, what about what he stated about the building code, providing that a bulkhead, and that's what he
Well,
said,
Your Honor,
that
if I
is, would
may,
not constitute a 4th floor. What's the proof?
the
What's
New York
the proof
City
you have
Building
that there is a
Code,
4th floor?
I'm sorry, the New York City Building Code does not control a exclusion found within a policy of insurance. The exclusions does not state pursuant to each locale's building code. If that was the case, obviously it would change from city to city, town to town, state to state. This is what a reasonable insured would view an interpretation of that exclusion.
So you're arguing
We
that
have
the bulkhead could, well, it could count as a fourth floor? Well, let me ask you,
Yes,
since
or not necessarily a fourth floor, Your Honor, but something above a third floor.
you are the entity that drafted the policy, so any ambiguity obviously has to be resolved against you under the law.
Very
So-
true.
So if it's totally ambiguous about whether that's a floor or not, isn't that construed against you?
No, Your Honor, because it's,
Because we have to decide the issue about the exclusion, right?
well, Your Honor, counsel is attempting to create an ambiguity by bringing in extrinsic evidence, i.e. the locale building code.
Well, it
That's
doesn't look
not
like a
part
fourth
of, that's
floor.
not part of the policy, part of the provision.
Let me ask them, I'm just looking at the picture, because that's the best evidence of what existed, obviously. And even if arguably that third floor, which is open, could be a floor, it really doesn't look like a fourth floor to me on the top. So what evidence is there that it is a floor?
Your Honor, it's unclear, and I'd like to
plans didn't
point out
call
that
for
the
a
lower
fourth-
court,
The plans didn't call for a fourth floor, so why, to the extent that there's ambiguity, it's resolved against you, why should we hold this?
Your Honor,
fourth
it
floor
looks
initial
as if they were
factors to
built, they were above the third floor. The plaintiff himself, in his verified bill of particulars, in his verified interrogatories, in his in the C3, in his own testimony, stated repeatedly that they were above the third floor. He then changed it.
Just one question in terms of how you read the exclusion. When we're talking about the highest point over 3 stories in height, that's at the time of the fall, at the time of completion of the work, or is that ambiguous?
Your
It's
Honor,
not in
that
there.
wouldn't be ambiguous. I think it would be clear that would be the height of the building at the time of the fall, what type of structure was in place. And at this point, the plaintiff himself testifies that they were above the third floor. In fact, Your Honor,
He said he fell from 4 to 3, 4 to 3. He mentioned that a couple of times.
he states that they were,
But doesn't
they
he
were working to
explain
connect
that
beams
that's
to
because he
create the,
counted the cellar as a floor?
under the New York City building code. But what would a reasonable insured view to be a floor, to be a story? To state that the insurer is tied into the local code for every venue doesn't make sense. There's nothing that ties us into that. This is, like any insurance provision, it's interpreted by the view of a reasonable insured. We have testimony statements from this plaintiff throughout the record stating they were above the third floor. We have an expert who stated it was above the third floor. I respectfully submit, as this court noted, I think 2 arguments before, that credibility issues belong to a jury. And that's what the lower court found, that there are questions of fact here, Your Honor. If I can, I just very
It's not really a
briefly.
credibility issue, though, it's an assessment of how many floors are in the building.
Well, credibility as to, do you believe plaintiff's statement earlier? Do you believe the expert? Which expert do you believe?
But then what about the picture that he identifies?
Picture, Your Honor, from my view of it, looks like it's above the third floor. It's, now, whether a jury believes that or they believe an expert's view of that, that's up to a jury. But respectfully, Your Honor, there are questions here, there are issues here which are just frankly not clear on the record.
Do you want to address the excess insurance?
Yes, Your Honor. I provided the court with an additional First Department case of Morrisania Towers versus Lexington Insurance Company, in which this court, in comparing 2 policies on the same level, note that because one negates contribution, it becomes excess above all other coverage, including other excess coverage. Contrary to counsel's statement, we are not stating that one policy is not excess and one policy is excess.
Neither of these
Obviously,
are excess policies, correct?
they're not excess paper. Neither of them are excess paper. But their other
So
insurance
they're both meant to
provisions
be
make both
primary-
of them excess.
Both meant to be primary policies.
Correct.
You're saying because one is worded differently than the other in terms of how it addresses contribution,
Exactly,
that
Your
should be a
Honor.
different result.
But that's how other insurance provisions are always utilized, Your Honor. You look at the other insurance provisions when
Doesn't
you have
that
two
subvert-
policies on the same level.
Doesn't that subvert the purpose of what these insurance policies are meant to be, though? If neither one is meant to be an excess policy, they're both meant to be primary, why should one be treated differently than the other?
Because one has verbiage in it that the other one doesn't. It's not a question of which policy is excess, it's how they interact with each other. By having non-contribution language, the policy that has that language, as this court has ruled, as the Court of Appeals has ruled in State Farm versus Lamoro, when you have policies that are on the same level and one does not have, or one has the non-contribution language, that policy becomes excess to all other policies on that same level. The policy which contemplates contribution goes first, and then the other policy. That's how they interact, because one policy says, hey, I don't contribute with any other policy, so you go first. Thank you, Your Honor.
Quickly back with respect to...
Counsel, why don't you start by addressing that issue, whether his argument about one expressly acknowledges contribution when the other doesn't, does that put them on a different footing?
In my brief, you know, I emphasize the fact that the decision is analytically backwards because it uses a contribution language, which is sharing, to determine priority. But sharing or contribution is meaningless unless and until two policies are deemed to be at the same level. That's priority of coverage. And priority of coverage is determined by the other insurance language. And both policies here say they are excess to any other coverage. That's it. Golden's relying on, its provision has more language, more words. But the fact that there's more words, kitchen sink type of stuff, doesn't do anything to negate that the Mount Holly policy also says it's excess.
What about the language in some of the cases he states, which does seem to suggest that distinction? Like the Utica
Right.
case, right?
It's the same passage from the Lamoro case, and it's been picked up in some of the decisions. And Golden, you know, cherry picks those decisions.
So what do those cases mean then?
Lamoro is an important case, but it's addressed to something totally different than this case, which is where you have a jumble of true primary policies and true excess policies. And what had happened in the 80s and 70s before that is, you know, drafters were trying to one-up and make a primary policy somehow magically sit atop all these excess policies. And the Lamoro decision was very common sense based and it said true primary policies go before any true excess policies. But this is not that case. We only have two primary policies.
So you're saying that extra language is meaningless in terms of determining the issue of one being excess over the other?
Your Honor, I would say it's inapposite to this type of case. And there are a lot of cases in this court and the other appellate divisions involving this issue where there are two primary CGL policies and there's an additional insured. And sometimes one policy is primary to the other.
What's your best case for the exact position you're articulating here, that where they're both primary policies and one has that language and one doesn't, it doesn't make any difference, it doesn't make one excess?
At page 21 of our first brief, we cite Kelmar, which I argued, and Sport Rock from this department, from this division, and a third, Federal versus Empire. Those are a selection of cases. They're not, there's more like them, and from the other departments, they were just exemplars of when you have two CGL policies that are determined to be co-primary.
Sports Rock doesn't address this particular scenario with the extra language, does it?
No, because...
So what's the case that, is there a case that does specifically address the scenario you're talking about?
I have not found a case that involves the exact same Mount Holly language and the exact same Golden insurance language because they are not standard forms. And these carriers drafted their language, you know, the verbiage varies from policy to policy when you're not using the standard ISO forms. But the analysis is the same. If both policies say they're excess, then neither policy can undo that to the other. Golden can't change the language of the Mount Holly policy.
You mean, and if both say they're primary, they can't undo it?
Your Honor, what I'm saying is...
Neither of these are excess policies, but primary policies.
They're both primary policies, and they both say, if there's another policy that applies, then we're excess to that policy. They try to leapfrog each other. So it's a tie. And what Golden is relying on is, what Golden is saying is, well, Mount Holly, you're not excess because we have more language. But the Golden policy can't undo any of the language of the Mount Holly policy. The Mount Holly policy says it's excess. And vice versa would be true too. The Mount Holly policy can't change. I would love it to. I would love Mount Holly's policy to be able to make the Golden policy say that it's not excess, but it can't. So we're at stalemate.
Okay,
Thank you, Your Honor.
thank you. People versus Martin. People versus Martin was supposed to be submitted, but there was a change in the calendar, so it got added back on. So, yes, that case will be next. For once, I'm not making a mistake.
Good afternoon, Leanna Duncan on behalf of George Martin. May it please the court. Your Honor, Mr. Martin is asking this court to consider the reality of what it means to be a person who struggles with addiction to be incarcerated in New York. Between 2001 and 2018, the rate at which incarcerated individuals overdose increased by 600%. This statistic, along with Mr. Martin's candid admissions to the court that during his previous incarcerations, he was using heroin and weed daily, are direct evidence of the prevalence of drugs within the prison system. Despite this reality, Mr. Martin's sentence requires him to spend 3 to 6 years in prisons which offer treatment programs which are both limited in availability and options. Placing Mr. Martin, a person who has been very open and honest about his struggles with addiction.
Eligible for parole on January 3rd, 2024?
Yes, that is correct. Placing Mr. Martin in a facility which offers limited treatment programs and in facilities which are oversaturated with drugs is completely contradictory to the purpose of penal sanction.
I can appreciate your argument for sure, but I just want to take a step back to when Mr. Martin took this plea. There were 3 other unindicted felonies. I mean, no, I'm sorry. Yeah, 3 unindicted robbery cases, felonies that he could have potentially faced, but this plea was kind of a universal plea to wrap that up. And so looking at it in that context, when he got 3 to 6 years, because I'm sure this is going to be the people's position, maybe you want to address it. The fact that he got 3 to 6 years is probably a good bargain for which he bargained for.
Right.
And
People
if I could
do.
just add to that, there's also the fact that it effectively, because it was concurrent time, covered the Albany bank robbery.
Right. So the People's Brief does mention the Albany charge and these 3 unindicted charges. With regard to the Albany charge, I would ask this court to take judicial notice that that charge was dismissed and sealed. With regard to the 3 unindicted charges, the people make reference that there was strong evidence of these charges, but that is not within the record. We do not know what evidence the people had about those charges. We do not know if they were even going to be indicted. We have no idea about the strength of those charges. We are asking this court to consider Mr. Martin's sentence for the 1 charge that he pled guilty to because of the evidence that was present, the 3 to 6 years. Placing Mr. Martin in a facility which has limited treatment options and is oversaturated with drugs is completely contradictory to the purposes of penal sanction. Mr. Martin is a non-violent offender who admittedly committed his crimes in the furtherance of his addiction. At age 17, he unsurprisingly...
Didn't he have a gun and threaten violence?
He didn't have a gun, Your Honor. He did...
He stated he had a gun.
He stated he had a gun. But I would ask this court...
Isn't that a potentially volatile situation which could have resulted in someone being injured, though? I'm just surprised you're saying he's a nonviolent based on
Well,
these facts.
as the prosecution pointed out, Mr. Martin has been, did plead to other third-degree robberies. None of these robberies involved violence. Even in the throes of Mr. Martin's heroin addiction, he wasn't a violent person. I'm asking this court, and Mr. Martin is asking this court to consider his lack of violence and that these crimes were just committed in furtherance of his addiction. And his addiction is not surprising given the trauma that he endured as a child.
Thank you. Thank you very much.
Thank you.
May it please the court, Amanda Regan on behalf of the people. Defendant's near minimum indeterminate 3 to 6 year sentence for a third-degree robbery was fair and should not be disturbed on appeal, particularly in light of the nature of the global disposition in this case. There were those 3 unindicted robberies that he was able to dispose of by pleading guilty, and he did receive concurrent time on an additional bank robbery up in Albany that he had committed. And all of the factors that the defendant cites as to why this court should reduce his sentence were squarely before the sentencing court and were taken into consideration in coming up with that plea deal that he agreed to. And, you know, to my adversary's point that there is the compelling proof of the other unindicted bank robberies was not part of the record, that's just not true. In the pre-sentence interview, defendant admitted to his interviewer that he had committed several other bank robberies, and that is also noted in our voluntary disclosure form that we provided, that he also admitted to several other bank robberies to the police at the time of his arrest. And in addition to that, all of these bank robberies were captured on surveillance video, and at least in the one here before this court, he was selected out of a photo array by the tellers who he handed. Not only did he verbally demand and threaten with a gun, but then handed a note to the same effect that he had a gun. So unless your honors have any other questions, we would ask that you affirm.
Thank you very much. I didn't give you rebuttal time because you weren't here for the countdown.
Thank you.
The next case is the Patner Project versus 320 West.
Good afternoon. May it please the court. Tom Mullaney from the Law Office of Tom Mullaney, Thomas M. Mullaney, for the individual appellants, Stephen Kirschenbaum and Ronald Winkler. In this action to set aside alleged fraudulent conveyances and other relief in aid of enforcement of money judgments, plaintiffs can be fully compensated by a monetary award, and thus an injunction will not issue because no...
Let me ask you something, because it does seem to be somewhat of a divide in our law and some inconsistencies in the law regarding this topic. I'm looking at 279 of the debtor and creditor law, the former debtor and creditor law that has been repealed, but was the law in effect at the same time that the former 273 was in effect. And I'm looking at it, and it says, it seems to me fairly clearly that where you've made out a showing under 273 that it's a fraudulent conveyance, certain remedies are available to you, including restraining the defendant from disposing of his property, appointing receiver, setting aside the conveyance. Why aren't those remedies which were enacted by the legislature available in this case if they are able to prove, which they obviously argue they have, that there's been a fraudulent conveyance under 273?
They may, but the law is very clear that in order to do that, even under 279, you have to follow the
Which law are you
preliminary
relying on?
injunctions. I'm relying on Dowey versus related companies, and I'm relying on Credit Agricole.
Okay, well, Credit Agricole does not involve the debtor and creditor law. That's a case with a fully unmatured creditor, and it makes no comment one way or another about how to apply the debtor and creditor law. And I understand Dowey does say that, but there clearly are other cases from the First Department which do not have that requirement. So I think we have to confront as a court whether or not that's a requirement that should or should not be imposed as a preliminary injunction.
Okay.
So looking at it from that lens, why shouldn't we accept 279 on its face, which doesn't refer to 6301, it doesn't refer to attachments. It seems to be, on its face, a remedy available in a case where there's been a violation of 273. So why would we look beyond 279 to determine whether or not the remedy allowed by 279 should be imposed?
Sure. Well, the case I was just reading from, those are not my eloquent words.
Sorry, the case what?
The case I was just reading from is Medallion Financial versus Sidrus. That is a case from this court from March 29, 2022. And two of the justices who are on this panel were also on the panel that heard that decision. And that is flat out
What's the site
says,
for that case?
I'm sorry?
What's the site for that case?
203 AD 3rd, 627.
Go ahead.
And that case flatly says, in this action to set aside alleged fraudulent conveyances.
That's dealing with the fraudulent conveyance.
Yes, that's right.
Medallion's dealing with the fraudulent conveyance, although I don't believe it per se cites to the debtor and creditor law, which I don't know what the briefs say on that subject, and I didn't have a chance to check that before argument.
Yes, well, it doesn't cite to the debtor and creditor law in the opinion, that's correct?
The opinion, I don't think it cites to, but it does speak of a fraudulent conveyance.
Yes, it does.
So how do we grapple with the language of 279, which does, on its face, appear to provide for remedies?
And I would just add that more recent case law out of this department has suggested along the lines of that the 279 would apply. I'm talking specifically about the Knickerbocker case from June of this year.
It would apply to what, Your Honor?
It applied 279 to allow injunctive relief.
Well,
without referring to any standards for a preliminary injunction being required.
well, that's a very different story.
I'm sorry, that's what?
That's a very different story. I mean, it applies, but does it apply without having to follow any other
Well,
standards for
that case didn't
injunctive
talk
relief?
about having to meet any other requirements other than a fraudulent conveyance.
Well, then, yes, if you look past the Medallion case and you look at the text of 279, so if I remember, 275D is then an exception that swallows what is an entire body of case law which prevents restraining an individual's...
Is Knickerbocker distinguishable because we affirmed the grant of summary judgment in that case?
Well, I was going to get, there are several cases, and that's one of them, where the decisions are not on injunctions.
It's also not dealing with money, it's dealing with the specific property, wasn't it?
But
No,
that's...
stealing. Go ahead.
It's for money, but it's restraining a specific piece of property.
Yes, so if...
A specific piece of real estate.
Yes, so if you're attempting to restrain arrests, that is different than fungible money.
It was trying to restrain the rest in order to satisfy a money judgment.
That's still different in all of the case law, and it's not
You're saying
just New York.
It's different if you try to restrain property versus trying to restrain people's funds.
Absolutely. If there is a...
So if these judgment debtors had an apartment, it would be okay to restrain that, but it wouldn't be okay to restrain their bank account.
Well, we don't have to get into that. If there is a specific risk, the standard is different. But here there is not. Here it is just money. It's a money judgment that's being sought. It hasn't even been achieved. And can you restrain an individual's assets without following the preliminary judgment requirements? In fact, can you do it at all until there's a judgment against them?
Okay. I'm looking at 273,
Yes.
which clearly applies to unmatured
Yes.
creditors who clearly don't
Yes.
have a judgment. And
Right.
273 lays out what you have to show as an unmatured
Yes.
judgment creditor to establish a fraudulent conveyance.
Yes.
And then I'm looking at 279, which lays out the remedies available when there's a violation of 273. How does 273 or 279 incorporate the standards for a preliminary injunction just upon reading the statute and what the statute requires?
They don't. On the faces of the statutes, they don't. Case law imposes that, but the statutes don't include that.
So why does it make intellectual sense to superimpose the preliminary injunction standards on 279, which seems to provide a remedy on its face for a violation of 273?
Because that's what's been done in courts over and over and over, not just in this state. In the United States of America, the Supreme Court, it's not a debtor and creditor law, but you can't, it violates due process under the United States Constitution to restrain someone's property until there's a judgment against them. And
but we
without
don't
even
have-
following the preliminary injunction requirements is doubly offensive to the Constitution of the
The
United
relief that's sought here is a preliminary injunction.
The relief that's sought here is a preliminary injunction, that's correct. And if I could get to the point on 273.
No, I'm going to let you do that on rebuttal.
Okay. Thanks. Good afternoon, Your Honors. Jason Stern, Weber Law Group. We represent the petitioner's response in this case. Preliminarily, I just have to say, on the issue of fraudulent conveyance, it's clear under debtor-creditor law, 273, 273A, and 276, these respondents violated debtor-creditor law. They fraudulently transferred assets out of an LLC to pay themselves.
Okay, let me ask you a question now.
Sure.
So there's two separate issues here. You did have a judgment in this case, and to the extent that you showed there was a fraudulent conveyance, and we uphold that, there's clearly a remedy that you get to attach any fraudulent conveyance assets. But as to the unmatured judgment, what about the cases such as Daley and other cases which clearly hold that in order to establish your right as to an unmatured judgment creditor to these funds, you have to satisfy the standards for a preliminary injunction?
Well, two things, Your Honor. One, I think Knickerbocker and other cases say I don't need to satisfy those standards, and there is no distinction between a monetary award or property. In either case, there are assets in the possession of a clear fraudulent conveyor. So that's my first point.
As I read your brief, and I'm sure it's not what you meant to say, but as I read your brief, inferentially, you really conceded to the position that they're arguing. Because there is no question that as to the judgment, and there is a judgment here, that you're entitled to relief. But then you get to this other pot of money to which you do not have a judgment. So at page 22 of your brief and going on to page 23, in dealing with the authorities which they have on their side, because they are pointing to really a pretty significant number of cases, and I point out that the Second Department unequivocally, albeit in the briefest of decisions, unequivocally adopted Delaney and the requirement that you cannot get the relief that you're seeking here. But you don't really address what Delaney stands for or what credit agricole speaks about. You say because all involved general creditors seeking injunctive relief, where unlike in this case, no judgment has been entered. There's no question as to the part of this case in which a judgment has been entered that you're right, but the rest of the case has no judgment. The inference from that is if you've got no judgment, those cases support that you're not entitled to the relief that you're asking for, and really that's what your brief says.
That was my intent,
It's
Your
not
Honor.
what you meant to say, I'm sure, and I'm sorry to put the question that way, but in reading it, I'm sort of left where else to go.
Well, I think the way to go is the statute. You look at debtor-creditor law, you look at the relief that a court is
Granted,
permitted to.
And it's a great point that debtor and creditor law 279 on its face seems to say you're entitled to relief, but then you get into all of the case law which is dealing with this issue from the Court of Appeals, and this court and the Second Department, which doesn't say that you're entitled to relief.
If I may briefly, I think.
I was going to add, how do you deal with the inconsistency in the case? Because there does seem to be some inconsistency.
I think-
How would you suggest those be addressed?
I think the point is, and this is what the legislature intended, when you've got a proven fraudulent transferor, there's an additional concern about the ability to recover the judgment. And that's what 279 lays out for unmatured claims, because if we've got someone who's acted in this way, a bad actor, the resolution is you're entitled to that additional relief.
So for money, and what we're talking about here is money, what case says that when you're talking about money?
I respectfully refer to the statute and the Knickerbocker case. You're right, Your Honor.
Which is
That
not
does
money.
You're right, Your Honor. I think the point's the same.
And we awarded summary judgment besides.
Well, Your Honor, the facts here, this is a special proceeding under 5225B, fully briefed, affidavits on both sides. It's effectively a summary judgment determination. I don't think that's a distinction. We've got affidavits, we've got deposition transcripts, admissions as to the conveyance of the assets. Hope that answers the questions of the court. I rest my brief. Thank you.
Thank you.
Yes, I'm not sure we didn't discuss this issue there.
Yes, thank you, Your Honors. So I would say, to answer Justice Friedman's question to Mr. Stern, it's the Galleon case that's a pre-credit agricole that permits under 279A restraining the assets. Those assets are going to Bermuda, if I recall correctly. But
So how is why does the Galleon case support what was done in Knickerbocker and what the petition wants
it does.
to do here?
It was, in my view, it was overturned by Credit Agricole, or at least heavily
But
distinguished.
you're saying it's overturned by Credit Agricole, but I'm a little confused by that. Just because Credit Agricole is not a debtor and creditor case. I mean, this provision in the debtor and creditor law, it's repealed now, but it's very old and it's been around for a long time. Credit Agricole had nothing to do with fraudulent conveyance loan, with whether or not there was a specific statutory remedy provided by the legislature in 279. So I don't really understand how Credit Agricole, as opposed to Daly, supports the argument that you're making.
Well, the theory of Credit Agricole is that if you're an unsecured creditor, you just can't restrain
Then it
someone's
wipes
assets.
out 273 and 279.
So let me get to.
Never existed.
I'm running out of time, so let me get
You're
to
out
that.
of time, but I'll let you answer that question.
Okay, thank you, Your Honor. So in 273, the fallacy of the argument on that point is that they are fraudulent conveyances, and they aren't. These were repayments of loans under a
But
loan.
let's say it's correct that if we make a summary determination in this case, or affirm a summary determination was made that these were fraudulent conveyances. If we affirm that summary determination, which is what a special proceeding it is equivalent to summary judgment. We would be affirming an express determination that there was a fraudulent conveyance in this case. And if we do that, the question that we must then confront is whether we can grant relief under 279 or whether we have to look to CPLR to determine whether or not to grant that. And I don't think Credit Agricole addresses that, but it is what we have to address.
I understand, but I would like to address the question of the fraudulent conveyance. Yes, if the court finds that the lower court was correct in finding a
Well, that's
fraudulent conveyance.
all, we're not going to get into that because that's a new issue. But
Okay.
Obviously, we would have to find that to even begin to have to address this issue. Because if we don't
Yes.
agree with that, then we'll never get to this.
Well, that would be itself an expansion of the law. So not only would other law be disregarded, but the creditor and debtor law would be expanded, because what would happen here is that a company that was perfectly solvent when the last contested loan was made.
Okay, that's a new issue. So I understand
not
the
a
issue.
new-
No, it's briefed in your papers. It's
Yes.
a new issue in terms of this argument, which it's in your brief. So we will consider that argument. So thank you.
Okay, it's also, I mean,
No, I
it's also.
understand that's part of the briefs, and we're familiar with the issue, and we'll consider
Yes,
that.
well-
Thank you.
Thanks.
Yeah. The next case is Sardo National versus Lobe.
May it please the court, my name is Rick Ostrov, and I represent Sardo National, the appellant in this matter. I've heard a bunch of times today discussion about how summary judgment should not be granted when there are credibility issues, and that's what happened in this case. In this case, at every turn, the district court made an inference against my client and found my client to not be credible. And the most notable inference that was drawn against my client was
Is that your client's not credible? Is that there was just no evidence presented to support the claim other than after-the-fact evidence?
well, there is evidence, my client's testimony. The court chose to disregard my client's testimony and find him not credible enough to accept that because it didn't draw any of the other inferences in my client's favor.
There was, I mean, it was a little bit more than that. There was like a period of time where some document surely would have been generated.
I don't see why, I don't understand the court's finding.
7
of that.
years or
Yeah,
something like
but there was no, under the agreement, as my client says it existed, he wasn't entitled to anything until there was a sale. Then there was a sale 7 years later, and then documents exist. There are email communications. He and both sides of the agreement were making a lot of money during that 7 years. Nobody wanted to rock the boat. Nobody saw any reason to rock the boat. There really is no reason why there would be a writing. And in fact, at 466 of the record, contrary to the district court or the lower court's conclusion, these were parties who don't do a lot of things in writing. I mean, really, it was a small sort of mom and pop shop that was making a lot of money. This isn't a huge corporate entity that had a human resources department. At 466, one of the top level managers there said they just rolled over the contracts and didn't have these things in writing. And that was consistent with what my client said too. But the biggest error and mistake that the lower court makes and that respondent doesn't acknowledge in their papers is the lower court said, my client was not credible, and this comes mostly in the summary judgment transcript because, I mean, the decision itself there wasn't a lot to it, but it referred to the transcript. In the transcript, the court says 3 times that, hey, this agreement where there was the make whole and the profit distribution and the lowering couldn't have happened together because the profits were distributed or that agreement was signed on February 15th. And the court accepted that as a fact. Now, at best, that's an issue of fact, but it's really not even an issue of fact because there's email evidence in this record that that date is the incorrect date and that the correct date is March 13th. So at best, it's an issue of fact, which we're going to win on at trial because there's no way to dispute the email, which they didn't even bother to try to do in their papers because the email is indisputable.
Counsel, if I may.
Yes.
The court also indicated that the testimony was conflicting. So I'd like to know what entity was it that made the promise of equity? What was the entity?
Okay, so that's a different issue of conflicting. One issue was the date.
Well, I'm going to get there, but go ahead.
One issue was the date, and just to address this issue squarely, the entity that made the agreement was Script Relief. Script Relief through Kimmy.
Let's stop.
Yes.
Because didn't the initial complaint indicate it was CNI, right? Because I thought there are 3 different entities. You have.
To tell you the truth, I don't know recall what
you have
the initial,
Scripps.
Yeah.
You have CNI, and then you have 20-star equity pool. So that's why I asked you, like, which one? Because there are 3 different entities that are named all over the place.
I agree, and this is what I think is the correct answer to the question. The correct answer is the initial contract and all the contracts were signed by Script Relief, which is now called Optum Perks, according to the respondent's brief. Script Relief was acting through Kimmy Scotty, who signed the Script Relief contracts, all of them, and Kimmy Scotty was the one who my client says made the agreement with him, and he agreed based on their discussion, and being that she was the one who signed the prior 2 contracts prior to the date of the conversation where he agreed to the make-whole agreement, it makes sense that she was representing Script Relief, which is now Optum Perks. And I don't think there.
Is there any evidence other than this claim that there was this make-whole agreement? Over the 7 years, is there anything which supports any documentary evidence that supports that this agreement existed?
Yes, there is.
What is
it's
that?
Not, what happens is, first of all, I just explained why I don't think there would necessarily be a document until there was a sale, because nothing was triggered until there was a sale. So that makes sense. If you don't believe it, maybe you think at best it's an issue of fact that a jury could consider, but it does make sense. Then the second there's a sale, automatically there is a flurry of activity, and including activity in writing. So what's the activity?
What shows that there is a make-whole
Let
agreement?
me answer the question. Well, I'm sorry, there were 2 questions. What was the flurry of activity? And I'm sorry. Okay.
Answer Judge Kern.
Okay.
Please answer her.
So the flurry of activity was the sale happens, my client learns about the sale. He picks up the phone, according to his testimony, which should be being accepted as true. He calls Lobe, he gets up on the phone with Lobe. He talks about the make-whole agreement with Lobe. Lobe doesn't dispute that the make-whole agreement exists. In fact, to the contrary, he says, okay, do me a favor, do the math, send an email to Vogel explaining how it works out. Then the email to Vogel is sent, and Vogel looks at the math in the email, which is unquestionably make-whole math, and Vogel doesn't say in response in email, hey, why are you sending me this? Why are we doing make-whole math? To the contrary, he verifies the make-whole math, says your numbers are very
We are
similar.
familiar with the papers. Do you have a question?
No.
Okay.
It's okay.
Okay, thank you then.
Okay. And then,
No,
thank you, as in I'm done?
Yeah, you have rebuttal time, thank you.
Okay.
I think you're done your presentation.
Good afternoon. I represent the respondents, Script Relief and Optum Perks. Your Honor.
Appellant makes that argument about the fact that Lobe doesn't say, "What are you calling me?" What's your response to that?
There was testimony on this in the case. What he clearly said was, and this is Vogel, was, I didn't know what he was talking about. I looked at the numbers to just add them up to see essentially what they were. And if you look at the email, what it says is, it says, as per JC, in other words, as per Sardo, this is what he says he's owed. There's nothing in there that constitutes an admission. The face of the document is quite clear that all he's doing is purporting to add up, 7 years after the fact, by the way, the math that Jason put in some sort of piece of paper and gave to him. And the testimony was very clear that there was no make-whole agreement, that nobody at the company was aware of a make-whole agreement, that there's no document. You asked a question whether there's any documentary evidence of one. The answer is no, and the reason we know the answer is no is because counsel was asked that question during the oral argument, and the oral argument and the response to that was that they would have to rely on Sardo's testimony because there was nothing in writing. And he also acknowledged at his deposition, Sardo, that there was no documentary evidence whatsoever. And let me make clear something that, something
Is this
that...
sort of an agreement to have a statute of frauds problem?
Yes, I just want to raise that issue.
The court didn't address the statute of frauds, sir.
The court didn't address any of them because it made a decision.
You raised it below.
We raised below a number of alternative arguments, all of which are perfectly appropriate for affirming, regardless of whether the court buys plaintiff's argument. Number one, there's a statute of frauds argument under two separate provisions of the statute of frauds. One which essentially says you have to have a written agreement if you are going to compensate somebody for introductions to sales, which is what this is under all of the case law. There's another one that says that you have to be able to satisfy the contract within a year. That's not possible because commissions are earned whenever a card is activated, not when a card is placed. So the way it works is if I take a card and I put this card, as Mr. Sardo might have done, in a Duane Reade, and then somebody takes that Duane Reade card and a year later fills a prescription with it, that's an activation. That's when they're compensated. So you cannot satisfy either provisions of the statute of frauds. In addition, for there to be a contract, and I just want to make clear that it's not just an issue of whether or not there was 7 years, any evidence in the 7 years that elapsed, an email from Sardo to Script Relief, an email from Script Relief to Sardo, some sort of reduction in writing of any aspect of the agreement. It's not just that issue. It's that the testimony with regard to the contours of this agreement was all over the place and totally contradictory. He, at one point, said that the agreement, my opposing counsel said that the agreement was with Script Relief. That's not what he said in his deposition. At one point in his deposition, he said, I don't know. And at another time, he said it was with the former owners of Script Relief, i.e. 20 Star. So he doesn't know who the agreement was with, according to him. He doesn't know what the contours of the agreement with. He said in his pleadings that he agreed to a $12.50 commission. Subsequently, it was reduced to $10. Later, well after this supposed make-whole proposition was made, never said a word about that. At one point said it was $12.50, at another point said he's owed $10. Doesn't know what the commissions he's entitled to are. Doesn't know who he promised him an equity interest. Doesn't know whether it's Script Relief. Doesn't know whether it's 20 Star. With this notion of, well, we're going to prove at trial that he signed it in March, not February, he pleaded in 4 separate pleadings that he signed it in February. we're told to disregard that because, well, we shouldn't care about a pleading. It's unsworn. They're his pleadings. The cases that they cite to the contrary are circumstances in which a plaintiff is looking to rely on their pleading as proof. This is the exact opposite. We're the defendant in the case. He said that he signed this agreement in February, which is when the agreement is dated. And that's what he said. Suddenly, now, we should take him at his word in a contrary affidavit that he signed it in March. And by the way, who cares? Because at the end of the day, that agreement was with 20 Star. The equity interest was with 20 Star, not with Script Relief, not with Optum Perks. So that would be the party, presumably, with whom he had this agreement, if any such agreement ever happened. So, you know, it wasn't just, let me just make it sort of crystal clear. If all a plaintiff needs to do to get to trial on an alleged 7-year-old agreement that he says exists without any corroboration, whether via testimony, in the form of emails, in the form of some sort of reduction of the agreement to writing, if that's all it takes to get to trial, particularly in circumstances where the plaintiff's testimony is all over the place, doesn't know who he had the agreement with, doesn't know what the contours of the agreement are, if that's all it takes, then there is no case alleging an oral agreement that can't get to trial. None. Because in this circumstance, that's what we have here, and that's what happened.
Thank you.
You're welcome.
By the way, they don't have testimony from Kimmy Scotty saying that what my client says is not true. So it's what he said, which is undisputed by the only other person who was there. And there's no reason not to accept it. Yes, it's
happened
true.
to Scotty?
What?
What's happened to Scotty?
I don't know.
He's out of the picture, isn't he?
Not deposed. I don't know. I don't think it's a part of the record, so I can't answer that question. And I don't know anyway, but not in the record, not disputing the facts here. This Vogel email that I was talking about, he says, oh, he just did the math. No, he said, quote, I see your POV, which is point of view. How could Vogel see his point of view without having some understanding that a make-whole agreement existed? Why does that whole email...
Does anybody ever say make-whole agreement? Anybody reference that?
It's not in writing, but I ask, and you've asked many people today, is there any case law anywhere that says that a period of 8 years is too long for there not to be a writing reflecting an oral agreement? There is not one. That's not the law. That's a factual issue that they can argue to a jury and should be able to argue to a jury, and a jury should be able to decide if that's true. Thank you.
The next and last case is Doherty versus 730 Fifth Upper.
Good afternoon, and may it please the court, I'm Josh Katz for the plaintiff's appellants. I have 6 minutes, and if I could, I'd like to at least reach 3 of the issues we raised in our brief. One is the prima facie standard for summary judgment, and the second 2 are how we think we rebutted their prima facie case, even if they had made one, which we dispute. So let me start with probably, if there's one phrase that you see in the case law more frequently than any other, it's that the movement in a premises liability case, if you want summary judgment on constructive notice, you have to put in evidence, whether deposition testimony or affidavit, saying...
Well, let's get right into the whole issue of the latent defect then, because if it is a latent defect, it's a different constructive notice analysis than if it's not a latent defect. So they're obviously taking the position it is a latent defect, and what's your response to that?
It can't possibly be latent. The latent defect, as I understand it, is something that's so hidden, so obscure, something that no one would ever think of, that it's reasonable not to...
As you look at the video and you say no one would ever think of, that sort of exactly fits this picture. You're walking through the door, it all seems to be perfectly fine, and just total surprise when this handle comes off.
Right, and that's, I mean, that goes to the sort of the res ipsa loquitur issue. This is not the type of thing that just happens.
We're gonna ask questions about res
Gotcha.
ipsa, because that's a separate thing than latent.
Right.
Let me just
Res-
ask
yeah.
this about the latent defect. Was that specifically argued, because with latent defect, you don't necessarily have to talk about notice. Was that argued in their summary judgment motion?
No, I don't, the move-ins did not argue that they weren't required to inspect because it was a latent defect that couldn't have been discovered even had they reasonably inspected.
Because didn't they say that they had inspected?
Right. I mean, and that's really the test for a latent defect. It's something that even if you had done a reasonable inspection, you couldn't have discovered it. And I think that clearly does not apply here. You can check the door handle and you can see whether it's loose or tight, and you can tighten it. This is just not the sort of thing that you could say as a matter of law would not have been discovered had they inspected it. And I don't even think there's a reference to that in their brief on appeal. I don't think it was anything argued below at all. I can go back and check. But I think the latent versus non-latent defect is really not the issue here. The issue is, when did you last inspect it? And when you inspected it, was it safe? That's all they had to do. Okay, if Dawn Wade, the security guard, who they say may have inspected it when her shift ended that morning.
Then what about the testimony about the problem with the other door within the weeks leading up to this accident?
Yes.
And that the testimony that there was a thorough inspection of both doors at that time.
Yeah, the testimony on that regard, it's at best equivocal. It's Mr. Seebeck, and he never says, I inspected the handle and it was tight. And on top of that, he doesn't know when he did this inspection, and it could have been any time within a 13-day period from July 4th through when this happened on the 17th. And again, according to Mr. Seebeck, it's not okay to inspect it once every 13 days. Their policy, and to keep things safe, requires at minimum daily. He said at minimum.
And there was no testimony specifically as to the daily inspection or even that morning of the inspection, right?
Right.
I'd just like for you to focus, before your time runs out, on the res ipsa issue, is particularly on the second prong, because that's really where this is going to lie. It's a door handle. Some may argue, or the case law might suggest, that it's not within the exclusive control of the defendant, say as an elevator latch, or but we have had cases where that's not necessarily the only thing that's required, right? It could be a chair, it could be a door handle, a sign that's set outside. So can you just speak on that?
So I mean, I think the key here is the particular door. I can imagine a situation where there's an interior office door, there's no camera, there's no one monitoring it. If that door had failed, I would say, sure, the public had access to it, you can't rule them out. But here you have a security guard stationed mere feet from the door 24/7, whose only job is to sit there and watch the door. And on summary judgment, the issue is whether could a reasonable jury look at all this evidence and say, you know, I think it's more likely than not that this was caused by the building rather than some stranger who somehow managed
Yeah, but wait, I'm
to
a
tamper
little
with the
confused,
handle.
because that's not my understanding of what res ipsa is. Isn't res ipsa that you have to show that they had exclusive control and that no one else could have caused this damage? So it's not more likely than not, it's that, is there some evidence that only they had control of the store? And how can that be the case for everybody who was handling the store every day? There were thousands of people walking through the store.
Sure. Well, I mean, I believe it's the Combat case, K-M-B-A-T, from the Court of Appeals that we cite. This res ipsa, the burden of proof is preponderance, just like anything else. And so to get to trial, all you need to be able to say is the evidence is sufficient to allow a jury to find, by a preponderance of the evidence, that this was not likely caused by someone else. All right? That's the ultimate question of the case. We don't need to rule out the theoretical possibility that someone managed to sneak in there and right under the security guard's nose, loosen the handle and escaped without anyone seeing it. I mean, if they want to argue that to the jury, fine, but at summary judgment, it's not our job to rule that out. All we need to show is that there's enough evidence in the record that a rational fact finder could say that, you know, I think it's less likely that this was done by some phantom vandal than versus the building. And that's really all that the res ipsa requires at summary judgment. And they even, I don't want to say they concede it, but I think they inadvertently concede, if I could just finish my point, I think they inadvertently concede this point in the brief because they repeatedly mention the fact that the door was constantly monitored and surveilled with cameras and a security guard right there. And that is enough for a jury to say, given this constant security, I just don't think it's more likely than not that some stranger came in and loosened the door handle while no one noticed. Thank you.
Any more questions before? Okay.
May it please the court. Jack Watkins from Kahana-Feld for the 5th Gen entities. Respondents?
Let me ask you the same question. Specifically, and I understand this is maybe a secondary issue, the latent defect, that wasn't argued specifically by you below, was it?
I think it was. I think it was adequately preserved, and I can refer you to specifically where we addressed it. The fact of the matter is that
Where's that?
It was addressed in the following locations in the record. It was addressed in the discussion in our moving papers at A84 through 88. We discuss in general the Gordon rules and the elements of visible and apparent. And then we do break out at A87 that here there's no evidence that this was visible and apparent at all, and therefore constructive notice can't be implied from the lack of an inspection. That is the latent defect rule. The words latent defect weren't used there. And then it was argued again on oral argument below, and that's at A20 in the record. We specifically pointed out that there was no evidence of when the defect came into being, so therefore the Gordon standard of visible and apparent for a sufficient amount of time in order to permit remedy. That, once again, that's the latent defect rule. So it's adequately preserved.
And I read your papers as well, as just why I asked the question, and I don't necessarily know if they,
No,
the way that you're putting it forward now, but anyway, continue.
But even if it was,
The res ipsa too, why it's not applicable?
yeah, I appreciate the argument my learned friend here is making, but there's ample case law. The Paris v. Port Authority of New York case, Port of New York Authority case. I don't know why it's spelled that way in the case name. The Dermatosian case itself, the Zimbler case, the Cohen v. Interlochen owners case, the Utroisi versus Merit Oil Co. case, all of which are in our papers, all of which are undistinguished by the plaintiff in their brief, all of which granted summary judgment on res ipsa loquitur, where the means of the accident was public facing and handled by many members of the public. I would
There
also
are other cases where the means of the accident, say a chair being broken, public facing, where summary judgment was in fact not granted. And that was a question for the jury, right?
Yes, so you have to try to figure out, as the court's asked a couple of times throughout the day today, how do you reconcile those? And there's something very interesting that plaintiff has said, both in his papers and just now in the argument before you. He said that we need evidence of a phantom vandal coming in and tampering to suggest that it's not more likely than not that we were responsible for this. But that's not what the Dermatosian case says. What the Dermatosian case says is that it's not whether the public interfered with it, but whether the public might have caused the damage. I would refer you to page A29 of the record, which is the oral argument, where my friend himself said, what we think happened here is that it was ordinary wear and tear that built up over time. Of course, members of the public could have contributed to the ordinary wear and tear that built up over time. There's absolutely nothing in this record to suggest otherwise. In fact, that's plaintiff's own case. So the idea that...
Actually, as you look at the video of the occurrence, the handle comes off and the glass just disintegrates. It's not you would have expected the glass might fall, but it just shatters, which is, it's not, it's as would seem to follow from the handle coming off, but why the handle coming off should cause the glass to shatter is,
I agree, Your Honor. It's a very strange thing. And if I can, I want to take a few moments to address that video and to address what plaintiff's expert says about it.
Plaintiff's expert didn't inspect the door handle, so we can appreciate that. But so why don't you just stay on?
Okay, then I'll fair enough. Then what I'll say is I'll confine myself to the video. When you look at the video, you're right. It happens in an unexpected and odd manner. But to the extent that plaintiff just advised the court that anyone could have inspected this because the only problem is that the handle is loose, I don't think that that's consistent with what we see on the video, number one. But let's say it's true, because that's their case. That is their case when they're talking about how we had a duty to inspect and it's not a latent defect. But when it comes to us saying, Every single day, we operate the door, we maneuver the handle, we put it back into place when we lock it, we move it to open the doors at the beginning of the day. Someone's looking at it every day. Also, dozens of people, maybe hundreds of people, are touching the door handle every day. No one's reporting looseness or any problem like that to us, which actually is, I think, contrary to what they say in their brief, I think that is admissible for constructive notice in the latent defect case, because that's been noted in pretty much every latent defect case there is, that no one drew anyone's attention to the problem. So which is it? Is our duty to conduct as the latent defect cases say, Ferris v. County of Suffolk, Paris v. Port Authority, San Andres versus 1254 Sherman, is our duty to conduct a reasonable inspection to see if it puts us on notice of some suspicious condition warranting a further inspection? I would submit that the evidence in this record is overwhelming that that was done time and time again, and no one noticed anything wrong with this door handle, including plaintiff himself. Thank you.
Good afternoon, Your Honors. Jason Fixler for CBRE. May it please the court, I'm going to prove my parents wrong, that I don't know when to shut up, and I'm going to rely on counsel's arguments with respect to latent defect and notice, and I'm going to focus more on CBRE and its lack of direct duty to the plaintiff as a managing agent. I'm going to dispense with the rule, which I'm sure Your Honors all are familiar with, Espinal and the exceptions to Espinal and the duty of a defendant to a plaintiff when they are not contracted to comprehensively and exclusively manage a property so as to displace the owner themselves from managing or maintaining that property themselves. CBRE in its papers carried that burden. In fact, counsel in his appellate papers writes, at the time of the incident, the fifth generation defendants, which were the owners, were joint owners and operators of the premises. Fifth generation employed a portfolio manager, Matthew Seebeck, who supervised the ownership and operation of the premises. The record is rife with what Mr. Seebeck did, directing CBRE, coming in and taking care of things. In fact, his expert, who I'm not sure how he can possibly opine as to the contract itself, actually offered the same thing. He actually said, and I apologize, I'm looking for it. Oh, I can't find it, I'm sorry. He actually said this along the same lines, that it was a joint operation, that ownership and CBRE maintained and operated the property. But it was the ownership that decided to repurpose this door. It was they who actually worked on the door. When it broke, it was they who fixed the door. In fact, during his initial argument, counsel mentioned Mr. Seebeck, who works for the owner. He didn't mention anything about CBRE. That is because the ownership took an active role in operating and maintaining and managing this property and directed CBRE in the manner in which it had done it. The contract itself controlled for the common elements management. The record reflects that the construction of this area wasn't completed until 2018. CBRE had a security service that it had contracted on behalf of ownership, and they were there in that room to monitor that area to see who was coming in and going out. However, that was all they did there, and it had not yet become a common element under the contract. Testimony of the ownership, they were unsure and could not pinpoint when, in fact, this vestibule area or this lobby area had been encompassed into the initial agreement, which was entered into in 2015, a year before this accident. What I think the council doesn't pick up on here is you can't have it both ways. They can't jointly manage the property. They can't jointly monitor the property and have it also be considered comprehensive and exclusive.
Thank you.
Can I just say one more thing, Your Honor? I'm sorry. Those words are absolutes: comprehensive, exclusive, displacement. If you have one piece of it that breaks it, then no duty. Thank you.
I wanted to come back to this latency issue. I'm not sure how this became about latency, and maybe my colleagues and I are just talking past each other, but my understanding of when a defendant says, we're not responsible because it's latent, they're saying, even if we did reasonable inspections, we wouldn't have found it because it's a latent defect, and therefore there's no causation. I mean, they never argued that here. I don't know how anyone could argue that on this record. It's a door handle that came loose. Their own corporate representative testified that we are supposed to be checking the door handle to make sure it's
The
tight.
latent defect is a door shattering.
Well, I mean, I think if you
the
look,
handle had just fallen off, obviously these injuries would not occur. What caused the injury was the shattering of the door.
well, I think if you look at the video, what shatters the door is the handle hitting it. The handle comes off and shatters the door. And I get it's not the best.
The handle shatter the door. The handle gets loose and then comes off, and the glass just shatters. I mean, it's just like.
Yeah, I mean, so it looks to me, and
hard
it's
to
not the
understand.
clearest.
One handle on one side and, sorry, one handle on one side comes off and then the other handle swings and shatters the door?
Yeah, I think if you look at the video, the handles obviously are connected in the middle through the glass, and it seems like the one on the opposite side comes loose first from the top 2 out of the 3 connection points, and then the other one also comes loose, and that's how the door shatters. I mean, I think that's what I think the video supports that.
Why
Ultimately,
should
it
the
would,
handle shatter that glass? It's a heavy piece of glass.
it is, and I think a jury could look at that video and agree that the most likely cause of the shattering was it being struck by the handle. I can't think of any other explanation. As we've said, glass does not spontaneously shatter unless something strikes it. I think that is the most likely explanation. But at the end of the day, it's not. If you want to say that the defect is there's some, I don't know, spider webbing in the glass that causes it to shatter, even that wouldn't be latent. I mean, it's a glass door. It's not huge. You should be able to inspect it and see if there's some problem. But our view is that the question of latency goes to whether the handle's looseness was something that they couldn't possibly discover through a reasonable inspection, and we think the evidence is clearly to the contrary.
Thank you.
Thank you.
All right.